the webinar. Over to you, ma'am.
Thank you, Rudrakshi. A very good morning to all. I welcome you all in this webinar, for which theme is Online Arbitration Issues and Challenges. Arbitration is one of the successful alternative dispute resolution mechanism. It involves the application of adjudicative mind with the previous acceptance of authority by parties. So EDR provides a conspicuous, speedy method of dispute resolution in the changing and fast-growing economy. Arbitration is one of the remedy to set aside a dispute to continue the economic progress. Online has made these benefits of arbitration more effective and efficient. Since the online mode saves human resources and time, therefore this is a very appealing mechanism of dispute redressal at national and international level. But this online arbitration also has its own issues and challenges. So to enlighten us on this topic, we have with us Dr. Vikrant Yadav, sir. Welcome to you, sir. I hand over mic to you, Rudrakshi.
Thank you so much, ma'am. Now I request respected Dr. Payal Thavre ma'am, Head of the Department of Post-Graduation Teaching Department, Rashtra Singh Tukdoji Maharaj, Nagpur University, to deliver welcome address.
Thank you, Rudrakshi. Respected Dr. Vikrant Yadav, all my dear colleagues and participants, on behalf of Postgraduate Teaching Department of Law, I welcome you all for the 9th national webinar of our 10 webinar series, which the department is conducting today on the topic of online arbitration issues and challenges. Certainly, as Deepali has rightly said, when it comes to online arbitration, we all are aware that there are certain wounds as well as certain veins which are there. And after the pandemic, before pandemic, we all were very much in a comfort zone of litigation. We all were in a very much comfort zone of redressal. But once we started facing the pandemic, we all have realized that automatically our life has shifted from the traditional mode to an online mode, and wherein the technology started overpowering almost all the facets of our life. And how can we left behind like arbitration? Online arbitrations were there from like since last decade, we can say. But after this pandemic, when we started knowing that technology is there for each and every aspect of our life, so certainly arbitration also started conducting through online arbitration mode. And I think today's lecture, of course, I know Vikrant very well, and I know he is quite experienced, in this particular subject, because this is, arbitration is his basic subject. So certainly he is going to tell us in detail about all the intricacies which are there when it comes to online arbitration, because this prefix online carries here, I think, more weightage than just the traditional word arbitration. So from like on behalf of Postgraduate Teaching Department of Law, we all are really looking forward for this insightful lecture. And of course, I'm extremely happy, and I'm feeling very, very happy because Vikrant happens to be my student as well. So I'm extremely happy and extremely proud to have Vikrant for today's lecture. So thank you so much, Vikrant, for kindly graciously accepting my invitation and enlightening us on this particular important topic of online arbitration issues and challenges. Thank you so much. Over to you, Rudrakshi.
Thank you so much, ma'am. I feel fortunate, lucky, and glad to introduce our today's eminent resource person, Dr. Vikrant Sopan Yadav, sir. Dr. Vikrant Yadav, sir, has completed PhD in International Commercial Arbitration from Pune University. He has more than 8 years of teaching experience in field of law. He has worked with some of the premier educational institutes like Modern Law College, Pune, Ajinkya D.Y. Patil University, Pune, and Government Law College, Mumbai. He has been associated with NICMAR, that is of Hyderabad, since August 2020. In pursuance of academic excellence, he has written and published more than 40 research papers, 3 books, and one book chapter, and is at present member of YIAG, that is London Court of International Arbitration, Young ICCA, International Council for Commercial Arbitration, and Young MCIA, that is Mumbai Center for International Arbitration. He is also on the editorial panel of some reputed interdisciplinary journals. He has delivered more than 20 guest sessions and webinars in various topics of contemporary relevance. I request you, sir, to please enlighten us over this topic of online arbitration, its issues and challenges. Over to you, sir.
Thank you so much, Rudrakshi, for that graceful introduction. And it is indeed an honor to once again get a chance to present in front of your mentor. So thank you so much, Payal ma'am, for that opportunity. May I have the right to share my screen?
We have made you co-host. Of course, I will make you.
Yes, yes. I am a co-host. I have the right. I mean, can I share
Yes.
it?
Now you can share it.
Okay. Is it visible? Okay. Thank you so much. So friends, as the ma'am has already told you and Rudrakshi has also mentioned that we are going to discuss about online arbitration. What are the issues in it, the legal issues. So most of you will be thinking that my discussion would be as to how arbitration happens in online form. Of course, that is the more core part of my discussion over the period of next 60 minutes. But apart from that, I'm also going to talk about something which is happening very recently and about which, unfortunately, not many of us are aware about in the field of arbitration. So the session is divided into 2 phases. First, we'll discuss about the very much known format of arbitration, which happens through the online platforms like which happens through the online platforms like Zoom, MS Teams, or WebEx. But this also, there is a different domain wherein online arbitration has been happening. It has been gaining a lot of momentum, and unfortunately, about which are the legal issues or the repercussions about which are not much known to the common fraternity, common legal fraternity. Okay, so that is something that we are going to have a discussion about. So let us move ahead with this. Just yeah. So when I was searching the internet about what exactly are the recent developments, I could come across a very excellent research document which was prepared by the Niti Aayog of India, wherein they have talked about the advantages and disadvantages of online dispute resolution. And I thought that I should share this picture with you, which will tell you clearly as to how ODR is more fruitful in dispute resolution than the traditional mechanism. Okay, so because ODR focuses not only upon the resolution part of the dispute, it also talks about or certain weightage, gives certain weightage to prevention of a dispute. Unfortunately, prevention of dispute is something which has been neglected a lot in India or in entire world community. Compared to West, in India, of course, we are way behind as far as prevention of dispute is concerned. Okay, today I'm associated with an institution which works in the field of construction. So most of the construction disputes what we observe today is that there is no mechanism for prevention. Whatever mechanism that West is following, we are not following it because it has its own lacunas. So how to prevent dispute? Therein the online mechanism can help a lot. Few of my students who are currently doing research under my guidance, they have evolved a mechanism wherein now we are in the phase of testing that mechanism, wherein a facilitator, an online facilitator will be appointed, who will have a communication common platform, who will provide a common platform to both the parties to have a good communication between them with an object of preventing the dispute. So that online communication, it helps you because in that case you are not required to waste your time in traveling and meeting the other party. So most of the time communication does not happen in industry because of that requirement of traveling and that requirement of wasting your time. So because of which the communication doesn't happen. Now of course that element has been eliminated. With an online platform, you can within a second you can have a meeting virtual meeting which is as effective as the traditional mode of meeting, an offline meeting. Okay, so this online technology has helped a lot, not only in resolution of dispute, it is also helping us in prevention of a dispute. Okay, moving on to how exactly the online arbitration is conducted. First, let me tell you that online arbitration, though I'm using the term online arbitration, there have been certain alternative terms which have been frequently used and which you must know and must not confuse yourself with. That there has been a term used as cyber arbitration. Okay, I myself have written an article wherein I have preferred to use the term cyber arbitration. There is also a term called as arbitration, virtual arbitration. So we can say that these are the synonyms, but actually in strict sense, I won't say they are synonyms. There is a big difference between all of them. Okay, so we will not focus upon what is the difference and how it should be done. Our focus is upon online arbitration. So let us talk about how things happen in arbitration on an virtual platform, on an online platform. So when we talk about an online arbitration, there are basically two types of online arbitrations. One is called as synchronized online arbitration and other is called as asynchronized online arbitration. Now, what is the synchronized and asynchronized? A synchronized arbitration is that arbitration wherein the entire time schedule of arbitration is prefixed. So before going to arbitration itself, in the arbitration agreement, we will finalize the timetable. Both the parties will finalize the timetable that by the end of first month, we will complete the filing of statements. By the end of second month, we will complete the oral hearings. By the end of third month, arbitral tribunal may give a decision. So such kind of time schedule, prefix time schedule may be prepared. And if such kind of prefix time schedule is prepared and is about to, that arbitration will be considered as an synchronized arbitration. Whereas if there is no such prefix time schedule, or even if there is a time schedule but it has not been strictly followed with, then in that case that will be called as an asynchronized arbitration, online arbitration. So for example, if the claimant has filed a statement of claim and the arbitral tribunal has given certain time, let us say arbitral tribunal has given a time of 30 days for filing a statement of defense to the respondent. So that respondent may file within 30 days, at any moment he may file the statement of defense. So he may file it within 2 days, he may file it within 15 days, or may take 30 days also. So this is a form of asynchronized online arbitration. Whereas if the arbitrator says that the respondent must file statement of defense on the 15th of April, so that is a synchronized online arbitration, wherein the time frames, the time limitations are clearly defined and it must happen on the given date. Okay, so when we are talking about online arbitration, actually what we are saying is the use of technology to resolve the dispute. So how that use of technology could be? Is it so that entire proceeding should be conducted through online mode? The answer is no. So when we are talking about online arbitration, it can further divided into a fully automatic online arbitration or an hybrid mode of arbitration. So what is hybrid mode and what is fully online mode? In case of fully online mode, parties will share their documents through an online mode like an email, or they may create a drive to which only parties to the dispute and the arbitrator will have an access, a secure drive or a cloud storage to which only parties and arbitrator will have access, and all the documents will be uploaded on that drive or either may be shared by an email or may be uploaded on the drive, and concerned persons who are having access will be intimated that such and such document has been uploaded, and it becomes the duty of concerned persons, the other party and arbitrators, to visit the drive and to check that particular document. So in the traditional format wherein we were required to send a physical notice to the other party has now been substituted with a very easy mechanism that what I am required to do is just upload the document on the drive or send the document by an email, and that is construed as a valid delivery of document, and a proof of which can be produced by myself if it is required by the arbitral tribunal before the arbitral tribunal. I can just can take a copy of that sent email and take a screenshot of it and share it with the arbitral tribunal, members of arbitral tribunal. That's a proof that I have shared the notice to the other party. Okay, so this is the way in which a technology can be integrated into an arbitration. The second mode which I talked about, an hybrid mode, is a mode wherein we will have the combination of both technological aspects as well as the traditional practices. So what we will do is we will share the documents through electronic mode. Some of the meetings may happen through through video conferencing mode. Like today we are discussing through a video conferencing mode. So in same way, arbitrator may set up a meeting with both the parties, maybe by using a Google Meet platform or by using the WebEx platform. And the parties will join the meeting and then they will have discussion. And some of the meetings may be held in traditional form, wherein the parties will meet one-to-one in person. Arbitrators will also meet them at a place of arbitration, and then they will conduct few meetings in person. So when the combination of technology and the one-to-one meetings is used, which were used in the traditional mode, that becomes an hybrid mode of online arbitration. So wherein you are using both online platforms as well as the traditional platforms of arbitration. Okay, so when we are talking about an online arbitration, we are basically talking about these three modes of online. Okay, the online arbitration can be conducted through a video conferencing mode, or it can be conducted through an audio conferencing mode also. So instead of turning on my video, what I will do is I will just turn on my audio, and then we will both the parties and arbitrator will just turn on their audio and will record the audio proceedings and will conduct proceedings through an audio mode. So that happens generally in case of telecommunication meetings. Okay, so when we are this has been happening in the world of arbitration, that few of the meetings are conducted through phone. So we will just give a group call. One of the party will just initiate a group call, and then other party and arbitrators may join the call, and then they can discuss few things, can conduct a meeting on that group call also. So that is also called as an audio conference. So an online arbitration happening through an audio conference. That is also a recognized mode of online arbitration. And the next is, of course, a very common platform known as text arbitration. So text arbitration need not always be in the form of text sent through an SMS. An email arbitration or document submitted through an email may also constitute a text arbitration or online arbitration conducted on a platform of text. Okay, so you may certainly then ask a question that if text is utilized or used as a mode of communication, then how will actual communication happen? Because in case of text, I will send an email, then the other party will respond, then, so that uh, live transaction which happens through an video or audio conferencing, wherein an instant or spontaneous discussion happens between the parties, that is missing in case of text. Of course, that is missing in case of text arbitration, but that is the most suitable online method of arbitration in case you have agreed for documents only arbitration. Now, what is this documents only arbitration? If you have read properly section 29B of Arbitration Conciliation Act, therein it talks about the fast track arbitration. Under fast track arbitration, it has been provided that unless and otherwise agreed by the parties, most of the documents only arbitration, most of the fast track arbitrations will be documents only arbitration. So what is documents only arbitration? That means arbitrators will decide only based upon whatever that has been submitted in writing by the parties. Parties will not be allowed to have an oral arguments, to have an oral hearings. So no parties will speak anything. They will only submit whatever they want to submit through an text, and based upon that text document, the arbitral tribunal will take the final decision, will pass an award, and that an award will be enforced. So in case of documents only arbitration, text mode is more suitable mode of online arbitration. So these are the three modes which are most commonly known, and I'm sure that most of you already know that these are the platforms which we can use for the online arbitration. Now, before moving forward, let us just quickly sum up, because I am sure most of you are already aware about these advantages. So let me just quickly go through as to why we should use online arbitration. What is wrong with our traditional mode of arbitration? If you compare online arbitration with traditional mode of arbitration, the online arbitration has the advantage of being more cost effective, more convenient, and more flexible. If you have had an opportunity of talking with any arbitrator, they will surely tell you that in case of traditional arbitration, the proceedings used to happen in 5-star, 3-star hotels, sometimes in 7-star hotels also. Because most of the time, the parties that are there to the dispute which is subject to arbitration are the commercial entities, like companies, multinational companies. So they don't bother as to how much amount is spent, because their ultimate goal or ultimate consideration is that to have a resolution, a speedy resolution to the dispute, because that is their interests are captured in that dispute. Okay, so they want to get rid of that dispute as soon as possible. So they don't think about how much element of cost is involved in resolution of dispute. But of course, if the cost is going to be less and still you are going to get the same result, people are going to prefer online arbitration than the traditional mode, because traditional mode, as I have told you, since they are happening in the 5-star hotels, 7-star hotels, and the time duration that was required to conduct the traditional arbitration was also more. Okay, so in fact, prior to passing an amendment of 2019, there were few instances of arbitration wherein the cases were handled or they were dragged for 5 years, for 6 years in case of arbitration also. So if that is the thing that is happening in arbitration, then what is the use of arbitration? Then it is happening in the same mode in which it is happening in the courts. Courts also take 5 years, 10 years, 15 years. Okay, so considering that, the Indian legislators fortunately have put a break to that and have now laid down the time limit under section 29A and 29B. So of course that time limit is there, but if you are adhering to, or if you are accepting the online mode of arbitration, then it becomes a very fast mode of arbitration. There have been certain instances wherein dispute has been resolved within 2 months, within 3 months. Even high cost claims have been resolved within 3 to 4 months. Okay, so that is very much possible with the active use of technological developments, especially various platforms which have been developed wherein the ML and AI integration has been done. So that there it has become very faster. So when I discuss that slowly, I will take you from the legal domain to the technological domain, because that is the need of an hour. Because without taking you to the technological domain, I won't think I will be doing justice to the topic that we have undertaken for today's discussion. So we will move towards that direction slowly. So cost effective, convenient, and flexible. Flexible parties can meet at any point of time. Okay, so previously all the parties were required to have consensus that okay, on this date we will meet at such and such place. Then that place booking was also required to be done. That is not required. Now not required. Okay, if it is an online arbitration, I can simply send a text to the other party. Do you have time? Can we meet now? And if the party is okay, if the arbitrator is okay, they can suddenly within 2 minutes start the meeting. Okay, so that is how fast the arbitration has become. That is how flexible the arbitration has become. Convenient it has become. Okay, quicker than the traditional hearing that we have already discussed. Efficient management of documents. So in traditional mode, as I have already told you, that I was required to send the document through a post or through the physical mode. And again, that used to take 10 days, 5 days, 2 days, 3 days, depending upon the mode through which I have sent the document. Again, most of the time it used to happen that even though I have sent the document at correct address, it was not delivered to the recipient. And then recipient is claiming that I have not received the documents. So that used to create a lot of problems, procedural issues. So now that has been eliminated. Now what I am required to do through in online arbitration is just send an email. I just have to confirm that I am sending it to correct email and just click the send button. If within one click, the document is reaching to both the other party as well as to the arbitrator. So that has become a lot of that document sharing, document management has become a lot of easier. And of course, as I have already told you, that if you are instead of sending emails, if you created a common platform like a drive to which only parties and arbitrator are having access, then that is the faster mechanism, even convenient mechanism than email. Because in case of email, I need to check, make it sure every time that I have entered a correct email address. Okay. In case of drive, I need not confirm that. I just have to sign in and upload the document. Once it is uploaded, it is the duty of other parties to check that document. Okay, so that is a more faster mechanism of sharing and managing the documents. Again, everything is stored on cloud, so there is no chance of saying that I have lost a particular document. It is readily available on the cloud. Any party can have access to it. Can reduce or eliminate the additional cost and inconvenience of unnecessary travel. So that point we already discussed. Remote witness testimony. Now this is also a very convenient part, because previously what used to happen, that even though I know that let's take an example that Rudrakshi is a witness to a contract that has happened between myself and some other party. And if I request Rudrakshi to kindly be present in physical mode in an XYZ hotel we have arranged the arbitration proceedings, Rudrakshi may be very hesitant to attend that proceeding because she may have that fear of remaining present in front of arbitrators, or she may not be willing to spend an entire day because she has to travel to that particular place, remain present, and then give her testimony, and then again come back to her place of residence. So in these cases, what used to happen is witnesses were reluctant to take participation in arbitration proceedings. Often the arbitrators were forced to take help of court in order to force the witnesses to give the testimony. That element has now been removed. Because of this online thing, Rudrakshi can now very much sit in her home and participate in the arbitral proceedings that we are conducting from our respective places. Okay, so she now needs to give only 5 to 10 minutes or 15 to 20 minutes or half an hour, depending upon her testimony, nature of her testimony. She now needs to give a very less amount of time, and to which she is very ready now, because under traditional form she was required to waste entire day of hers. Now in the online mode, she has to give just 15 to 20 minutes, wherein one party will ask certain questions, other party may ask certain questions, and with arbitrator may ask certain questions. And once she inform everything that she knows, that's over. Okay, so that has become very easier for the witnesses also to give their testimony, and that has helped the arbitration procedure also, as the witnesses are now more willing to participate in such proceedings. Again, let me tell you that certain incentives are also given in such cases. Okay, witnesses are also paid certain fees, or certain incentives are also ensured in some arbitration practice. Arbitration, there has been a practice that witnesses were given certain incentive for wasting their time, because ultimately they are giving their valuable time for the case. Okay, so that practice has been there. Next is documents can be accessed remotely. So that we have already discussed that through, if it is uploaded on cloud, I need not have I need not approach the every time for getting an access to the document. I can access it easily from my home. Available, accessible, and friendly technology. Now, if you search even today on internet, if you search the topic of online arbitration, there have been many articles wherein the problem has there have raised an issue that technology is not accessible. Of course, it depends upon which country you are living in, but in a country like India, I would say technology is pretty much accessible. Because even in the states like northeastern states wherein I have traveled recently, I found out that 4G technology is accessible. Even in the remote places, 4G technology is accessible. So I don't see technology as a hurdle. It has become more accessible, at least in India. I'm not talking about the African countries. Therein the problem is still there. And slowly we are moving towards 5G generation. So that is going to again increase the accessibility and availability of technology. So that is another advantage which is forcing us to move towards an online arbitration. So when we are conducting an online arbitration, what are the basic things that we should take care of? The first thing is have a demo or practice round, because there may be few persons who may not be well versed with the technology like me. I'm not very well versed with the technology, right? So if person like me is a party to arbitration who is not very well versed with technology, how to handle the technology, then it is necessary that before you start the arbitration proceeding, you must ensure that the concerned party has been given a proper training. So this is required to be done under the principle of equity, that the person is properly trained before using that method of online mode of arbitration. Okay, if that training is done, if all the logistical um, uh, necessities are ensured, then you can move on with the online arbitration. The second thing that you need to ensure is, of course, you can have certain practice round also in order to avoid problems. So certain practice meetings wherein you can ask the parties to share documents, you can ask the parties to share their views through an video conferencing, through an audio conferencing. So that testing is required to be done. So even though you know that the parties are so you may be an arbitrator in a case wherein both the parties are MNCs, multinational companies. So even in that case, you must not assume that multinational companies will have the best technology and will have the properly trained staff, so there won't be an issue. No, don't assume things. Ensure it by having a proper practice rooms, that there is a proper availability of technology and there are no problems. Now, in spite of ensuring this, there may be a problem. Like just at the beginning of this session, I ensured everything. I had two sets of headsets with me. I had ensured that my the internet connection is good. Still, there was certain audio issue. So that kind of things still happen. So what is to be done in this case? That in spite of preparing ourselves for a video conferencing, we could not meet virtually because of certain technological issues. So in that case, you have the alternative platforms of text communication or text meeting, or you can have the alternative platform of audio meeting. So you can just give a call to all the parties and arbitrators, and then through telecommunication conference you can have the arbitration proceedings, which I have told you that they have been in practice already and they have been recognized as a valid mode of communication. Okay, so time allocation and management is something that you need to take into consideration, particularly when the parties to arbitration are belonging to two different nations. It is an international commercial arbitration, and the parties belong to altogether a different part of the world. For example, if one of the parties is from India and other party is from USA, you need to, every time you arrange a meeting, you need to take into consideration the time difference. Okay, because in USA the time zone is different, in India the time zone is different. So that you need to take into consideration. Okay, next is logistical and technological specifications that you need to ensure that the participants have access to technology, and the time zone difference which I have just now talked about, that also you need to take into consideration. Depository of e-documents. Okay, so that also we have discussed that you can create a drive, maybe a Google Drive or any other cloud platform wherein you may create a drive, and you may encrypt it. You can give unlimited access only to the other party and to the arbitrator, so that the confidentiality part of arbitration is maintained, which is required to be done under section 42, recently amended and inserted section 42 of Arbitration Conciliation Act. Okay, next is guiding protocols. So you may lay down the or the set of norms that are required to be adhered to in conduct of online arbitration. Like there have been certain instances wherein the courts were handling the online procedure during COVID situation, and the lawyers were attending online proceedings, and they were sitting in a very casual attire, and they turned on their video, and then the judges found out that the lawyers are attending in a casual manner. In one case, in fact, it had happened that a lawyer was sleeping on the bed and he was attending the online proceedings of a court. So such kind of things shouldn't happen in arbitration. So for that purpose, the arbitrator must prepare the set of norms, some ethical norms which must be adhered to by both the parties as well as by the arbitral tribunal, members of arbitral tribunal also. So that also is required to be done before commencement of online arbitration. And then you need to ensure the security and privacy element also, because whenever the online arbitration is being discussed, the most discussed issue is that of security and privacy, confidentiality. So how to maintain that security and privacy? First thing is, always use those platforms which are secure enough. Okay, so today I joined this WebEx meeting because I have been provided with a link. So only those persons who are having an access, who are having the password to the meeting, can join the meeting. So such kind of while fixing the platform for arbitration, you need to make sure that the platforms are secured enough. No, some unknown person or intruder should be in position to join the meeting and should be in position to gain access to the documents that you have shared. So that security element has to be taken into consideration, for which you may resort to various technological advancements that have already taken place. Of course, many arbitral institutions are now coming up with their own platforms. Okay, I will give one or two examples in the due course of time, wherein the arbitral institutions have created their own platform which are more secured. So that is also an option, that instead of using these platforms like Zoom and WebEx, you can just submit your dispute to an arbitral institution and they will take care of entire thing. Even the security and privacy matter will be taken care of by them. But of course, when you submit it to institutional arbitration, you should be ready to pay higher cost, because they are going to ensure everything: administrative assistance, technological assistance, everything is going to be ensured by the institution. Appointment of arbitrators, so institution is going to charge certain fees for that. So that fees is going to be higher than the ad hoc arbitration. If money is not concerned for you, better refer your dispute to institutional arbitration and tell them that we want to conduct an arbitration through an online mode. So they have their own platforms through which the meetings can be conducted. Okay, so these are the basic things that you need to ensure. Now, the most important element of our discussion is that it is legally accepted. We may conduct an online meeting. We may accept the evidence through online mode. Arbitrator may give an award through online mode, but is it legally recognized? As far as India is concerned, the answer is yes, it is legally recognized, because Section 52 of the, I have mentioned Indian Act, it is actually the English Act. Okay. So Section 52 of English Arbitration Act requires that the arbitration award may be in a form which has been recognized by the parties. Okay. Even if you see the Swiss law, Section 189 Clause 1 of Swiss Code provides that the arbitration award could be, or the procedure could be, in the form which has been agreed upon by the parties. Again, same thing is given under Netherlands. Netherlands law is very specific. It clearly states that it can be through electronic mode also. So it is not that online procedures, online awards have not been recognized. The freedom has been given to the parties. Parties will decide whether the online arbitration should be conducted or not. And if the parties decide or agree upon online arbitration, then that is a accepted version of arbitration that is pretty much recognized under law. So as far as Indian law is concerned, Section 7 Clause 3 clearly tells us that an arbitration agreement must be in writing. So then what is in writing? What if I have prepared an arbitration agreement draft online, and I have shared it through an email to my other party, and the other party has digitally signed that? So can that be considered as a valid arbitration agreement? So as per the logic of Section 4 of Information Technology Act, yes, whatever that is required to be in writing, if it is performed through an electronic mode, that is considered an equivalent to in writing. Okay, so when this arbitration agreement is required to be in writing, and that is agreed to in the form of an electronic agreement, that electronic agreement is pretty much in the form of an in writing, and that is pretty much recognized in India. Even through various judicial decisions, the judiciary has time and again accepted electronic arbitration or electronic communication as a written communication. Okay, for example, in these two cases, it has been clearly stated by the Supreme Court that the documents duly approved and signed by the parties in form of exchange of emails, letters, telex, telegrams are a valid telecommunication, are a valid written communication. Okay, so this has been a well settled principle that if you communicate through electronic mode, that is considered equivalent to an in writing. So when Section 7 requires an arbitration agreement to be in writing and it is in the form of electronic mode, that is pretty much complying with the requirement of Section 7. So what exactly is the procedure in case of online arbitrations? The procedure is pretty similar to the traditional mode of communication or traditional procedure. The only difference is in traditional procedure, it used to happen in one-to-one meetings sitting across the table. In case of online, that happens through a virtual platforms. Like we have discussed various platforms till now. Okay, like MS Teams, Google Meet, Zoom, then WebEx, etc. So what is the procedure? So we will go into the details of procedure. First of all, the parties need to select the platform through which platform they are going to conduct the arbitration. Once that platform is agreed to, like one of the party may be convenient with the Zoom platform, and other party may be convenient with the Google Meet platform. So in that case, the arbitral tribunal will have to decide which platform is to be decided for arbitration proceeding. In deciding that, arbitral tribunal should give the highest priority to the security element of arbitration. Okay, arbitral tribunal should choose that platform which is more secured, and if the parties are not well versed with it, then it is the duty of arbitrator to give training, proper training to the parties and ensure that the parties are well versed with that particular platform. So the one which is more secured, because if you remember, in the initial phase of COVID-19 lockdown, people suddenly started using Zoom platform, but after 1 or 2 months, it was realized by the users that the Zoom platform is not secured enough. Any person can join the Zoom meeting and it could be intervened. So that was realized. Then suddenly Zoom also realized their problem, and then they upgraded their technology. So they made it encrypted. So such kind of encrypted platform should be selected wherein the intruders cannot gain an access to an online arbitration procedure. So that security should be the concern while selecting the platform for arbitration. Next is request for arbitration. So how that request for arbitration will be sent? That request may be sent to the other party through an email that we already have an arbitration agreement. I'm hereby giving you a notice of arbitration that since we are having a dispute, let us refer our dispute to arbitration, and then the other party may respond to the notice, or you can directly refer the matter to arbitrators. In the meanwhile, you are supposed to appoint the arbitrators. So that appointment of arbitrators can also be done online. How it can be done online, that we will discuss in a very short while, because from here and after, the discussion is going to be almost on a different platform. So we will discuss that. Selection of arbitrators, filing of statements of claim and defense, and then so that also happens online, that I will have to prepare my statement and submit it either through email or through on a drive, and then the other parties and the arbitrator will go through that statement. Framing of issues, that again has to be done by the arbitral tribunal. So once the facts are established, the arbitral tribunals will face the frame the issues, and that will be communicated to the parties, and then the parties will have to upload the evidence witnesses through a virtual mode. So documentary evidence will be uploaded on the drive, and witnesses are required to be presented. They will be presented through a meeting, virtual meeting, or video meeting, video conferencing. Then the oral hearings may take place. Why I have mentioned oral hearings in a different color form is because oral hearings may happen, may not happen. Okay, oral hearing is not a requirement or is not a stage in every arbitration. It is conducted only in that arbitration wherein the parties have agreed for an oral hearing, or it is conducted only in that form of arbitration wherein the arbitrator has permitted oral hearing. So like I have given an example of section 29B, wherein if the parties have agreed only for the uh, documents only arbitration, then in that case document only arbitration, there will be no oral hearing. Okay, so that is subject to agreement and subject to permission by the arbitral tribunal. After that hearing, award will be prepared by the arbitral tribunal, a draft will be prepared, and that award, copy of award will be signed by the arbitrators, and that will be again uploaded on the drive or will be shared through an email, and then that will be enforced. So that enforcement again, if the parties comply with it, fine. If the parties do not comply with it, you will have to go in court of law. In court also, fortunately, they have started conducting online proceedings, and if you go through that Niti Aayog document, which I talked about in the first slide, you will come to know that even in Indian courts, we have made a lot of progress, and in future also, we are going to continue with this online proceeding thing. So it would be better if we have this enforcement proceedings online mode also, through online mode itself. So I think that may be a possibility in nearby future, but as of today, there is no option of enforcement proceedings carried out through an online mode through a court. Courts may conduct it online if there are any restraints like lockdown, and if there are no such restraints, court will mostly do it through a traditional one-to-one form. So wherein you are required to be present before the court, and then court will go through the award, and then court will enforce the award, pass a decree of an enforcement. So this is the process in the online arbitration. Next biggest question is, we have conducted arbitration proceedings. Now the award is also given through electronic mode. Whether that award is enforceable? The answer is yes, pretty much it is enforceable, because as per section 31 of Arbitration Conciliation Act, it clearly states that an arbitral award shall be made in writing. So again, we have discussed that as per section 4 of Information Technology Act, if something is required to be in writing and it is done in electronic form, then that is equivalent to in writing. Okay, and shall be signed by the members of arbitral tribunal. Okay, so the signature part, can it happen through electronic mode? Of course, yes, it can happen through an electronic mode. Nowadays, we have the option of signing the documents digitally, digital signature, right? So if the digital signature is put, then again that physical signature requirement is not there. It will be assumed that the concerned person has signed the document. So you can scan the signed copies in the PDF format, because PDF format is considered to be more secured. You cannot edit it, and then you can again, you have the option of encrypting it. You can encrypt the PDF file. You can put an password to that PDF file and share it. So in that PDF software itself, the integrated option is there. So if you go in the files option, therein you get the option of coding the file and sharing it to the other party, and then you can share the code through other secure mode. Email with digital signature, that has been a reality, and which has been recognized under section 5 of Information Technology Act, that digital signature have the same effect as per the paper signature. That I think everyone knows today by now, so let us not spend much time upon it. The very interesting factor in this online arbitration is what will be the seat of arbitration. Because if you are meeting through WebEx, for example, can we say WebEx is the seat of arbitration? The answer is no. WebEx cannot be called as seat of arbitration. WebEx can be called as a venue of arbitration. Okay, so Balco has already taught us, Balco versus Kaiser Aluminium, Supreme Court has already taught us the difference between seat of arbitration and venue of arbitration. If you have not read that case, I would request that you please go and read that particular case wherein the difference between seat and venue has been clearly mentioned. That is not our discussion, point of discussion for our today's discussion. So let us not go into that domain because that will again take a lot of time. So seat of arbitration is basically very important for arbitration because based upon seat, we can determine whether it is foreign seated arbitration or it is domestic arbitration. Again, in domestic arbitration, if the seat of arbitration is in Nagpur, then the Bombay High Court or the Nagpur bench of Bombay High Court has the jurisdiction. If the seat of arbitration is in some, let us say, is in Hyderabad, then the Telangana High Court has the jurisdiction. So, seat of arbitration plays a very vital role in determining what type of arbitration is it. Is it domestic arbitration? Is it foreign arbitration? Foreign seated arbitration? So that by and large depends upon the seat of arbitration. So in this virtual platform, what is required to be done? What the parties are required to done is that they have to agree upon the seat of arbitration. So they may conduct the proceedings through online. So right from document sharing till award sharing, everything will happen through online mode only. But this online arbitration will have seat in XYZ place. For example, let us consider Nagpur as a place of arbitration. So that seat must be mentioned by the parties in the arbitration agreement, even though they may conduct the proceedings through online mode. Okay, so even though you have from traditional to online mode, you must agree upon a particular place as a seat of arbitration, and that place must be mentioned in the arbitration agreement. What if parties have not mentioned that seat of arbitration? Then in that case, arbitral tribunal will have to mention that seat of arbitration, and then as per the seat mentioned by the arbitral tribunal, the jurisdiction of courts will be determined for the purpose of interim relief or for the purpose of challenge to the arbitral award. Okay, so seat of arbitration is required to be mentioned even in case of online dispute resolution. Even in case of arbitration, you need to mention the seat of arbitration. This has been accepted practice even outside India, like in case of American Arbitration Association, AAA, under Article 1, they have clearly mentioned that conduct of arbitration through video conferencing will be deemed to have taken place at a place of arbitration. So even in case of video conferencing arbitration or online arbitration, you are required to mention the physical place of arbitration, because though the award is given through an online mode, it will be assumed that the award is given at a place which has been mentioned as a seat of arbitration in the arbitration agreement itself. So, few minutes back, I mentioned you a fact that few of the arbitral institutions have started using their own platform. Okay, so 2 examples I have given over here, that in case of European communities, arbitration and mediation centers have already started using e-arbitration T. E-arbitration T is the platform which they are using for conducting online arbitration, wherein you just need to visit the platform, sign in, create your account, login ID and password, and then through that login ID password, you can submit your dispute to the concerned platform, and then they will appoint virtual arbitrators. Virtual arbitrators will be given an access to you, and then you can have the meeting with the virtual arbitrators. They will give an award, and then again a copy of electronic award will be given to the parties, and that's how the dispute is resolved between the parties. Even in India, certain arbitration institutions have already started using it. Like for example, just a second. So for example, this IDRC, Indian Dispute Resolution Center, has already started a platform called as e-arbitration. So in that e-arbitration platform, you can, right from filing of the dispute till the award, everything is done through that platform only. Parties are not required to meet in person to each other. Okay, so such kind of platforms have already been developed by the arbitral institutions. All that you need to do is you just need to submit your dispute to them. That also happens online only, and then everything is taken care of by them. Of course, if you are using these platforms, then you should be ready to pay more fees as compared to the ad hoc arbitration, because as I have told you, since everything is being taken care of by the institution, they will charge certain extra fees than the traditional mode of arbitration or than the ad hoc mode of arbitration. As far as Indian government is concerned, fortunately, I could come across one example. You can visit this website of samadhan.msme. So in MSME sectors, most of the arbitral disputes are arising from this MSME sector. So therein they have created this MSME Samadhan platform, wherein all the disputes in the MSME sector will be referred to the platform. You can file the complaint online by creating an account on this Samadhan platform, and then that complaint will be forwarded to the juror, that is the arbitrator, and that arbitrator will advocate upon it based upon the evidences that both the parties have submitted, and he will also conduct a video virtual meeting if it is necessary, and then he will give an electronic award, and then that award will be enforced. So Indian government has also fortunately started taking steps towards this e-arbitration or online arbitration. If you are interested, you can just visit that particular platform, samadhan.msme.gov.in, wherein the option of electronic arbitration has been offered to the disputes in the field of MSME sector. Now, this is something which I have been talking about. The thing which has not been touched upon by many Indians, which has not been discussed a lot, a technology which is at a very novice stage, but which is going to be a future of arbitration. I would rather say it has already occupied a lot of portion of online arbitration. So blockchain-based smart contract arbitration. So what is this blockchain-based smart contract arbitration? So here and after our discussion will be more of a technical domain discussion or a discussion based upon the technology. So what is this blockchain technology that we will discuss in the next slide. Before that, I will just like to cite the statement of Honorable Justice D.Y. Chandrachud. A legal professional from across the globe are also suggesting implementation of smart smart contract arbitration, where dispute resolution takes place electronically on a blockchain. The arbitration clause is coded into a smart contract, where the arbitration would be the algorithm itself. Okay, so I might have created a lot of questions in your mind, and I will slowly try to answer all these questions, because these questions are not an easy to answer. They are a bit difficult, particularly if the audience is non-technical audience. So what is smart contract? That first let us understand what is smart contract. Then we will understand what is blockchain, and then we will proceed to understand what is blockchain-based arbitration. Okay, so smart contract is basically a contract which is a coded contract, which is uh, encoded in the blockchain or in a block. So we will, for example, I will prepare a draft of a contract. I will show it to the other party. We will both sign it, and then we will upload the copy of that contract on a block. As soon as we upload that contract copy on a block, that copy becomes unchangeable. Neither me nor the other party nor anyone in the world can change that document. Once it is uploaded, it is uploaded. You cannot make any change. You can replace that document with some other document, but you cannot change the already uploaded document. Okay, so it is that document which is self-executing electronic instructions drafted in computer code. So it is self-operative contract. So in a contract, if it is mentioned that I will supply certain goods to Madam Payal on so and so date. So what Madam Payal is required to do is she just required to confirm that she has received the goods. As soon as she confirms on blockchain that she has received goods, automatically the amount will be deducted from her account and it will be credited to my account. And this payment happens in cryptos. Okay, it doesn't happen through the electronic payment that we do through NEFT or Google Pay. No, not that way. All the transactions that happen in this blockchain technology, they happen in the cryptocurrency. Okay, so for that purpose, I also need to deposit certain cryptos once I upload the document, contractual document. Madam Payal will also be required to deposit certain cryptos. As soon as I have delivered the documents, whatever cryptos that Madam Payal has deposited against the payment, those cryptos will automatically be credited to my account. So what has happened in this smart contract? What has happened is we have eliminated the role of third parties. Who are the third parties? Had we conducted this contract through a traditional mode, we were required to approach the banks for initiating the payment. Okay, so if Madam Payal wants to transfer certain amount to me, then in that case she need to place a request with her bank that kindly transfer so and so amount to Vikrant. then the bank will take action. How much time it will take, that we don't know. In case of IMPS, fortunately now that happens in a faster manner, but still she has to place a request with the bank. The bank will not automatically transfer that amount. Okay, so the element of bank is involved in this case. Whereas in case of smart contract, which happens through blockchain technology, she need not do anything. All she need to do is she just need to confirm on the blockchain that the goods have been delivered. Goods which have been agreed in the smart contract have been delivered, and then the blockchain will take care of everything else. The payment, how the payment should be done, how much payment is required to be done, because all of that has already been agreed in the contract which has been uploaded on the blockchain, a code. A contract which we have uploaded on the blockchain is a code. So as per that computer code, the payment will get initiated automatically. So smart contract does not require human interference for enforcement. It automatically gets enforced. Okay, so I hope I have helped you understand what exactly is a smart code. Again, I would like to now talk about arbitration. So automatic resolution. In case of arbitration conducted in blockchain, through blockchain, it is an automatic resolution by automatic selection of person, panel, artificial intelligence, agent chosen on the basis of preference, identity and qualification indicated by parties whose decision would be directly enforced. Okay, so what exactly am I trying to say here? That if while performing the contract between me and Payal ma'am, if I have supplied the defective goods to Payal ma'am, so what Payal ma'am is required to do is, instead of confirming the receipt of goods, she needs to raise a dispute. She needs to place the click the button regarding dispute upon the block that we have created, blockchain that we have created by uploading our contract. And as soon as she creates a dispute, she initiates a dispute, automatically the instructions will be sent to an arbitral institutions that there exists a dispute between the parties involving a smart contract. Arbitral institutions will consider what are the requirements of arbitration. Arbitrators, accordingly, automatically the arbitrators will be appointed by the arbitral institutions. Those arbitrators will get into touch with the parties, of course through virtual platform only, and through a virtual platform only the arbitrator will give a decision which will again be automatically enforced. So how it will be automatically enforced? So let us say if Payal madam is saying that the goods which Vikrant has delivered to me are defective goods and hence I need a compensation of 10,000 rupees. Okay, so then the dispute, I am saying, I will say that no, whatever goods I have submitted to you are in accordance with the agreement, are in accordance with the contract, and I don't think I am required to pay any compensation to you. So now there is a dispute. So she will raise a request for dispute resolution. So again, automatically the request will be sent to the arbitral institution. Which arbitral institution we don't know. Whatever persons who are appointed or who are available as arbitrator on that particular blockchain platform, they will automatically get the request through blockchain technology, and those who are with the description of qualification, with the description of arbitrators that we have provided, those will be automatically selected as arbitrators, or we will get the option of choosing arbitrators, that these are the 6-7 arbitrators who are fitting to your description, kindly choose your arbitrators, and then both me and Payal madam will choose our arbitrators, and those arbitrators will adjudicate upon the dispute. If the majority of arbitral members consider that Payal madam is entitled for 10,000 rupees of compensation, then as soon as the decision is given by the arbitral tribunal, automatically my cryptos will be deducted and the cryptos equivalent to the value of 10,000 rupees will be credited to the account of Payal madam. So now what Payal madam is required to do is nothing. She just needs to relax in her chair. Automatically the amount is going to get credited into her account. She did not even go to court for enforcement of arbitral award. So this is the beauty of blockchain based smart contract arbitration. Okay, so let us discuss it further in detail how exactly it happens. So when I'm talking, so till this point I have not explained what is blockchain. Okay, so what is blockchain? If you break out this word into two words, you will understand what is the meaning of blockchain. Blockchain means combination of two words, block and chain. So when I create a contract or I give an offer to some other party, it could be open offer to anyone which is available on the blockchain. So let us say this entire platform is a blockchain platform. So I will give an offer that I have certain goods which I am ready to sell. So that offer may be accepted. So in our example, Payal ma'am is the acceptor. So she will accept that offer through blockchain only. So this offer is one block. whatever I have given written in that offer and uploaded on the code in the form of code on the block, that will not be changed, cannot be changed by myself. Once I uploaded it, it is permanent. I cannot change it further. Okay, so the offer is constant. So the investors, the acceptors have now the confidence that yes, now this offer is not going to be changed. Because in traditional form, what happens is today I may give one offer and tomorrow I may retract that offer and may change that offer a bit. That change option is not available in blockchain. So there is a certainty, there is a guarantee that this is going to be the offer till the end. So Payal ma'am may accept that particular offer and then it will become an acceptance. So again, as soon as she creates an acceptance, a second block has been added to the chain. So as soon as the acceptance is there, now there is a contract. So we may again prepare a separate in detail draft of a contract. We may discuss the draft of a contract, which we will again upload on the block chain. We will add it to the chain, the hash chain that we have created, and then the block is created, which is of a contract. Now the next point is that of performance. So what I need to do is I just need to deliver the goods to Payal ma'am as per the contract, and she needs to confirm the performance on the blockchain. That she will acknowledge. How she will confirm that? She will acknowledge through electronic mode on blockchain that I have received the goods as per the contract that we had agreed on so and so date. So as soon as she accepts it, blockchain will automatically treat the contract as completed, as performed. So everything from offer to performance is now stored on blockchain, and that can be accessed not only by us, even our future generations can accept that, can access that particular transaction if they have the key. So only those who are having key can access this particular hash blockchain. Okay, so currently myself and Payal ma'am is having that access. Tomorrow Payal ma'am may give that access to her children. So tomorrow, whatever business Payal ma'am is carrying out, her children may carry out in future. So they will also get to know as to what were the transactions that had happened sometimes before. So 100 years before, 500 years before, what were the transactions that had happened? Everything is stored permanently on the blockchain. Okay, so that is why it is permanent, it is unchangeable, so that it is secured. Why it is secured? Because whatever copies that we have uploaded, copy of offer, copy of document, that we have uploaded on blockchain, that gets stored on different computers. Okay, so even if you change a copy on my computer, copy on Payal ma'am's computer will not get changed. Okay, so though I'm saying it is on her computer will not have the copy. She will access that copy through her computer, through her account which she has created on blockchain. Okay, so different copies are created on different computer systems through which you access the blockchain, and then that becomes very difficult to breach or change that particular document, because you can change one document, but the same document is available on the other user's account also. So that also you have to change if you want to change the entire document. It is in that sense the blockchain is very secure technology. You cannot change it easily. The documents that are uploaded cannot be changed easily. So now we are not here to discuss blockchain. We are here to discuss blockchain arbitration. So let us consider that while performing this contract, there is a dispute. So what will happen? We will again add a block of dispute. So in this case, in our example, Payal ma'am is creating that block of dispute. So she will upload a document saying that there is a dispute, or she will click on the option of dispute. So the block of dispute will be created, wherein she may upload a document containing what exactly the dispute is all about. And then she will also upload, or we may jointly upload the copy of arbitration agreement. Once we upload the copy of arbitration agreement, in that arbitration agreement we may mention as to who exactly should be our arbitrator. So we may lay down the condition that the person who is having an experience of 5 years in handling arbitral matters, contractual arbitral matters, should be an arbitrator. So that is our requirement. So that requirement will be sent by the blockchain technology to all those who have made themselves available as arbitrator on blockchain. So all the persons, like if Dipali ma'am has made herself available as arbitrator on blockchain, so she will receive a request that there exists a such and such dispute and you fit within the requirements, so you can choose to be an arbitrator for them. So then what the Dipali ma'am has is required to do is she also requires to contribute certain cryptos. Okay, she, an arbitrator, is also required to contribute certain cryptos, and then she will give an award. If that award which Dipali ma'am has given falls under the category of award given by the majority, or if Dipali ma'am's decision falls or others to the majority decision, then she will get cryptos in return. Okay, so if she has invested 10 cryptos, she will get 30 cryptos, 40 cryptos, 50 cryptos in return, because she has practiced as an arbitrator. She has given a decision, and that decision which has been accepted by majority. But if her decision is not accepted by majority, then whatever cryptos that she has deposited will be confiscated and will be given to the parties to the dispute. Okay, so now the accountability of arbitrators is also ensured through this mechanism. Now arbitrators cannot say that even though my decision is not accepted by majority, still I will get the arbitrator's fee. No. If your dispute is accepted by majority, then only you are going to get paid. Otherwise, you are not going to get paid for your efforts as arbitrator, because your efforts are of no use to us. Okay, so arbitrators will automatically get a request, all the arbitrators available on the blockchain. Again, which arbitrators will get a request? Those arbitrators who are contributing more cryptos will get preference in terms of request for arbitration. So if Dipali ma'am has contributed 1,000 cryptos and some other arbitrators have contributed somewhere around 400, 500 cryptos, then first request will be sent to Dipali ma'am. If she accepts, fine. If she does not accept arbitration request, then the request will be sent to those arbitrators who have contributed lesser cryptos than Dipali ma'am. So preference is given to those arbitrators who have contributed more cryptos. And again, the more you contribute, more is the risk of losing that cryptos, because if your decision is not a majority decision, then you are going to lose all those cryptos. Okay, so more the risk, more will be benefit. That is the idea behind this blockchain technology. So everything happens in the same way in which it happens in the share market. Okay, it is a kind of virtual share market only, that you are investing certain amount, and you may get return subject to certain conditions, subject to happening or non-happening of certain events. Okay, so when we are talking about blockchain-based arbitrations, there are basically two types of blockchain-based arbitration. One is called as on-chain arbitration, and other is called as off-chain arbitration. So on-chain arbitration is completely based on artificial intelligence or machine learning assisted technology, wherein entire arbitration proceeding will be conducted through an AI-based technology. So automatic appointment of arbitrators will be done by the AI technology, and then parties, whatever documents that parties have uploaded on blockchain technology, uploaded on hash blocks, that documents will automatically be sent to arbitrators. Then arbitrators will go through the documents, and then they will prepare an award, and then copy of award will automatically be uploaded on the blockchain. So another block of award will be created. Okay, and that award will be enforced. So if the arbitrators are saying that compensation of 10,000 may be given by party A to party B, automatically the cryptos worth 10,000 rupees will be transferred to party B's account. Okay, you need not do anything. Everything gets automatically done. So it may happen that now you have raised the dispute, 2 hours you get an award. That may also happen. That is how faster the arbitration has become. Okay, so when we are talking about online arbitration, now the online arbitration is in this particular phase. Blockchain arbitration has become so fast and so automated that you are required to do nothing. Everything will be taken care of by the blockchain. Are people using it, this automatically complete on-chain arbitration? Is it being used? The answer is yes. Just before starting of this discussion, I visited a particular website, and therein I found out that more than 1100 disputes have already been resolved through that blockchain. Okay, so that tells you that a technology which is still at a nascent stage, which is still not known to many people, and still more than 1100 disputes have already been resolved. Okay, so you can imagine there has been a big buzz in the Western arbitration community that this blockchain arbitration may completely replace the traditional form of arbitration, which is conducted through online also. So when I am talking about traditional arbitration, I am not saying the physical arbitration. I am also talking about the arbitration which is happening through video conferencing mode. Okay, so this traditional mode of arbitration happening through video conferencing is likely to be replaced by a more advanced version of online arbitration, which happens through an blockchain technology. Another form of blockchain arbitration is hybrid mode, wherein arbitrators may conduct 1 or 2 meetings through the virtual mode, like MS Team platform, or like the Zoom platform, or like the WebEx platform. So 1 or 2 meetings if it is required, or in cases wherein physical inspection is required, arbitrators may physically visit the site or physically visit and check the quality of goods, and then they may give the decision. So that a hybrid mode wherein human intervention is required, wherein checking of due process is required by human intervention. So if the human intervention is required, you may choose the option of off-chain arbitration conducted through blockchain technology. So that off-chain arbitration, you get the option of conducting some meetings through offline mode, and then you can again go virtually, and then award will be given virtually. So this is blockchain arbitration, the process of blockchain arbitration. What are the highlights? It is open platform. Everyone can participate in it. Okay. Um, though I am saying everyone can participate it, for that participation you require an unique identifier key. So that key will be shared with arbitrator only after appointment of arbitrator. So the documents will be shared, whatever documents that you have uploaded on blockchain will be shared with the arbitrators only if you have confirmed their appointment through blockchain. Okay, not every arbitrator will get the access to your documents. Only those who are having key of access will get the access. Decentralized structure. So as I told you that every document that is uploaded on a blockchain is kept on, a copy of it is stored separately on each different computer. So that is why it is a decentralized system wherein an encrypted security is also there. So there is, it is extremely difficult to interfere with blockchain documents. It is very difficult. It is called as hash security model. So once the hash security is added, no one can penetrate into that block. That becomes an completely protected block. It cannot be intervened into based on the will of users. So as long as we so whether to go for blockchain based contract or not, whether to go for blockchain based arbitration or not, that is completely upon me. We can decide whether we should go for it or not. Okay, unless and until you give consent, it will not, that automatic process will not initiate. That automatic process will initiate only once you say yes. But once you say yes, there is no coming back. You cannot come back and say I don't want to comply with it. No, once you say yes, it will directly end up by enforcing the arbitral award. Okay, so that's the beauty of blockchain arbitration. Elimination, it eliminates the human errors, because in offline traditional mode, often it used to happen that certain technical errors were used to be there in the arbitral award, or parties used to frequently send communications at the wrong address. So such kind of problems will not happen now. It will get communicated only to the party which has been given access to. Only that party can access it, and the errors are also removed, because now AI based algorithm is used to check the documents, to verify the documents. Again, in the previous slide I used a term NLP. So if the parties are belonging to two different nations, and they are different, speaking different languages, like one party is speaking Hindi, other party is speaking Dutch language, so in that case they can use the NLP technology, which will automatically transfer the content that I'm speaking in Hindi into a Dutch language, and that will be communicated to the other party. So while I'm speaking from this side, I will speak in Hindi, but when the other party will hear it on the other side, it will hear it in the language which that other party understands. So that NLP based integration of AI model is also something which is helping a lot in having the communication, cross-border communication in the arbitration, blockchain arbitration. Blockchain-based smart contracts, we have already discussed all these things, but the issues, what are the issues in blockchain-based arbitration? Is it issue-free? The answer is no. Even in case of blockchain arbitration, there are a lot of issues which are required to be taken care of. So what are these that we will discuss? That we will discuss. The first is agreement in code. So whatever document that you upload on this block, that you once you upload it, that gets converted into a form of a code, computer code, and that computer code cannot be changed. So that cannot be changed may be a problem, because contract is something which may require certain flexibility. With the change in time, you may require to change the contract, so that cannot be done. So you, while preparing contract, you need to be very futuristic, and you need to take into consideration all the future possibilities that may take place. All the price escalation clauses and everything must be mentioned in the contract at the time of uploading contract itself. Later on, you cannot change it. Once it is done, no going back from that. Okay, so you need to be very sure before uploading documents on block. Then next is neutrality is promoted by UNCTRL also. So UNCTRL through the amendment of 2006 has already conveyed that electronic mode of arbitration is accepted. So there is no question that blockchain arbitration is not admissible or not acceptable. No. If you apply the logic of UNCTRL law, which was passed in 2006, that is very much recognized mode of arbitration, and you can enforce the arbitral award. In fact, there is no need of enforcement of arbitral award. That award is automatically getting enforced through the blockchain itself. Seat of arbitration is a very much important element that even in case of blockchain, since it is happening virtually, though it is happening virtually, in the arbitration agreement that you are uploading on block, you need to mention what is the seat of arbitration. Okay, you cannot leave it like that. You need to mention the seat, and then only you can proceed with the arbitration, because that is very important element. If at all you want to challenge the decision in court, or if you want at all you want to take help of courts, then which courts have the jurisdiction, that will be determined based upon seat only. So better mention the seat in the arbitration agreement itself. Okay, next is money influenced appointment of arbitrators. So this I have already talked about, that the one which will that arbitrator which is contributing more money will get the higher number of cases. Again, you can control how many cases you should get. If you are free and you can entertain many cases in a day, you can make that option available, that concerned arbitrator is free and can handle many cases in a day, so he will get more number of arbitration cases. Whereas if you are busy, then you can choose the option of having only one case in a month. So that option is also available on blockchain. All you need to do is you just need to contribute certain cryptos, how much that is upon you. If you contribute lesser cryptos, you will get lesser cases. If you contribute more cryptos, you will get more cases. Okay, arbitrability, that is a very important element that is unfortunately not clear as of today, because who will decide arbitrability? Everything is computerized, everything is technology generated, automated. So who will decide whether the matter is arbitrable or not? So if you ask me the question, it is the AI based model which will determine whether it is arbitrable or not. And if that AI based model is itself biased model, then in that case arbitration itself is going to suffer with biasness. So that is going to be a big issue, that whatever AI based model that you are applying, which is determining the arbitrability of a dispute, should be developed by the developers. Algorithm should be developed in an unbiased manner. Then lack of equitable access, equitable decision making is another biggest problem in this blockchain technology. If you see the warnings of section 28 of Arbitration Conciliation Act, it clearly says that the parties have a choice of law, and in that the arbitrator will have to apply the principles of equity. So arbitrator can give assistance, special assistance, if it is required by one of the party. For example, if I am not well versed with technology, arbitrator can arrange one session for me, which is giving a training in the field of technology, so that I can use that platform in a better manner in arbitration proceedings. So that special attention, if it is required by one of the party, that can be given under the principle of equity. But that doesn't happen in case of blockchain. Blockchain doesn't consider whether you are well versed with technology or not. It will automatically start operating, automatically will refer the dispute to arbitrator. Arbitrator will decide upon whatever documents that you have submitted, and automatically the arbitrator will upload the award, copy of award, and then automatically that award will be enforced by blockchain technology. So in that process, you don't get a chance to present the case. So oral hearing does not happen in case of automated blockchain technology. So in this previous slide which I talked about, on-chain, this on-chain arbitration, which wherein everything happens automatically, you don't get an option of oral arguments. Everything happens on documents. Whatever documents that you have filed, based upon those documents only the dispute is decided. So parties are not getting an opportunity of presenting in oral form. So that is another problem of blockchain based smart contract arbitration. So these are the problems. Of course, we still, I think I have exceeded the time limit. So I would try to wind up the things now. Conclusion. In conclusion, I would say that change is the thing that is eternal in this world. Change, you cannot stop the changes. Changes are going to happen, and you must be prepared to adopt yourself to the changing technology. If you do not adopt yourself to the changing technology, just blaming technology will not suffice. You can point out the lacunas in the technology, no doubt about that, but you cannot say that blockchain will never be successful in India. In fact, it has already started becoming a successful model of arbitration resolution process in India also. Okay, so if tomorrow someone like me or someone like Dipali ma'am or someone like the attenders in this session, if you want to start yourself practicing as arbitrators, all that you need to do is you just contribute certain cryptos and make yourself available as a juror, as an arbitrator, and then the cases will start coming to you. You can online decide the cases online, and then if your decision is in majority favor, then you will get the fees. You will if you have contributed 10 cryptos, you may get 50 cryptos, 100 cryptos. So your benefit will get tripled 10 times. It depends upon how much exactly the cryptos are contributed by the parties to the dispute. What is the future holds? Future, of course, blockchain is going to be the future. But apart from that, I also pursue robotic arbitration as a something which is going to happen in future, wherein robots will act as arbitrators, or robots will present the case on behalf of parties, and then robots will prepare the award, and robots will render that award, and that will be directly enforced. The WTO itself has accepted this fact of blockchain, that yes, blockchain is going to be the future of international trade, and something which is going to be the future of international trade is going to be the future of international arbitration also. So no doubt is the future. These are the resources that you can visit and get acquainted with yourself with if you are interested. Particularly, I will highlight this person, Mr. Noam Webner. He has uploaded a lot of documents on internet regarding ODR, online dispute resolution. So you can visit these resources and get yourself acquainted with. Thank you so much. And I can see many questions were asked during the discussion. So if someone could read out those questions, because I have already told you I'm not very good in technology. So someone can help me in that regard.
Sure, sir. Thank you so much, sir, for your insightful knowledge about the topic.
Yes.
Am I audible, sir?
Yes, Rudrakshi.
Okay. Thank you so much, sir. I just remarked your words in I was really, it was an insightful webinar, that the acceptance of virtual dispute resolution is not ununanimous, through though the use of video conference and virtual hearings provides a viable alternative to international travel and in-person attendance at an arbitral hearing. Uh, there are few questions. The first question is by Ravindra Pandey, sir. He has asked about that he has worked that have we tried with tools like WhatsApp or Telegram in India, as he has worked in 17 countries as IT corporate trainer. So he have been migrated to many such tools, but among lawyers he never find lesser enthusiasm. So what do you think, sir?
Yes, what he is saying is to an extent it is correct that in India such kind of tools have not been exploited a lot, because there has been a hesitancy in the mind of lawyers, in the mind of arbitrators, as to whether if we use WhatsApp as a platform for arbitration proceedings, and tomorrow the award is challenged in court, whether court will accept this or not. So that kind of hesitancy is still there. But if you ask me, in my opinion, yes, very much it is acceptable, because whatever happens through WhatsApp, a copy of it can be produced in front of court, a written document can be produced, written record can be produced in court, and hence it is enforceable, it is acceptable. It is just the need of time that someone should start using it and start utilizing it, because that is the most accessible technology that we are having today. So if WhatsApp or Telegram can be used, there is nothing like it.
Okay, sir. So the second question is, how can we regulate the unilateral appointments of the arbitrators by the banks to arbitrate the loan default cases where they are alleged to be biased towards the banks only?
This altogether is a different area of discussion. There has been a lot of discussion as to what should be done, do in this, particularly the standard form of contracts, wherein the arbitrators are appointed unilaterally. So in the, there have been various cases which have been referred in courts, and wherein the court itself has given two different opinions. That in certain cases, court had said that this is not at all in accordance with principles of contract. The mutual consent element is lacking in it. And again, the parties, there is an opposition which is saying that, opposite view which is saying that yes, when you sign the standard form of contract, therein itself you have given the consent. So you cannot say that the consent has not been taken. So we still need a clarity on this particular point. But if I have to think from the consumer point of view, then yes, we need to bring certain changes wherein a specific requirement, a separate consent for arbitration and appointment of arbitrators by mutual consent is necessary. But as of today, the law of arbitration says that it is up to the parties how to appoint the arbitrators, and then if you have consented to standard form of contract, then you have given the consent to the appointment done by the other party. And when the other party, one party appoints the arbitrator unilaterally, that is very much an valid arbitration appointment, arbitrator appointment as per section 10 and 11 of Arbitration Conciliation Act. So unfortunately, that is the truth, and that is the correct method.
Much agreed, sir. So there is one more question that is there any provision in arbitration if any of the parties pampered the confidential documents unanimously? It will be a challenge to find out the culprit. So how to deal with such situations?
Breach of confidentiality is a ground available under public policy. A public policy is a ground available under section 34, section 48 and section 57 of Arbitration Conciliation Act. So 34 is applicable in case of domestic arbitration, and 48, 57 are available in case of foreign seated arbitration. So if the award is seated in a is given in a country which is having seat in New York Convention, which is in a country which is party to New York Convention, then that award is enforceable under part 2, 1 of Arbitration Conciliation Act, and under section 48 you can challenge the enforcement. So yes, what you are saying is correct. This award can be challenged if the confidentiality has been breached. Apart from challenging validity, can you bring action against a person? The answer is yes. For that, you need to initiate a separate action in the court of law. For that, arbitrator cannot initiate action because arbitrator's jurisdiction is limited to 2 parties before the arbitrator. So for that, you need to approach the court under the information technology laws.
Due to time consumption, I'll just take 2 last questions, sir. That won't the government's decision not to recognize the cryptocurrency hamper the blockchain arbitration?
How does it matter? Because whatever government decision is, whatever government thinks, today most of our young generation has already contributed cryptos, is already there in the blockchain world. Okay, so government cannot have control over it because these things are not national. They do not have seat in any country, so they cannot be controlled by national forces. That is the beauty of blockchain, and that is why the government of India was also forced to adopt the blockchain technology, wherein it said that RBI will itself bring its own cryptocurrency. So that is a formal acknowledgement by the government that yes, we are also accepting it. So there is no question of non-acceptance by the government. It is already accepted. They have to accept. There is no option in front of them. Unless the entire world community comes together and puts a ban upon blockchain technology, that is not possible.
So the last question I would personally ask that, so why every time ODR is been focused on commercial dispute only?
Because in non-commercial disputes like matrimonial matters, it is not that it is focused only in commercial disputes. What you are saying is applicable in case of arbitration. So online arbitration is more by and large restricted to commercial disputes, but ODR, other methods of ODR are being used for other non-commercial disputes also. Like family disputes are resolved by way of mediation, labor disputes are resolved by way of conciliation. So these other non-commercial disputes are also being resolved by way of other modes of dispute resolution. Particularly negotiation has been used a lot for various types of disputes. Even the criminal disputes, yesterday only in my class I made a statement that criminal disputes can also be resolved by way of negotiation. If the other party, if I have contributed loss to the other party, I have thrown a stone and suddenly it hit a person, a passerby, and that passerby comes to me and says that if you do not pay me compensation of 10,000 rupees, I will go in police and file a complaint against you, and I pay 10,000 rupees as a compensation. That is a negotiation only. Okay, so online dispute resolution methods can be utilized for non-commercial disputes. Arbitration by and large is restricted to commercial disputes because of the higher stake values that are involved in it.
Do you think that India is lacking for? So do you think that India is lacking for providing it for non-commercial things?
I won't say India is lacking. The entire world community itself is referring only commercial disputes to arbitration because commercial disputes are of such a nature that they require a certainty in decision making. In case of mediation conciliation, that certainty in decision is not, rather decision itself is not there in case of mediation conciliation. In case of arbitration, there is an end to your dispute somewhere. Okay, so that end is required to be put because the interest that is involved, the value that is involved in commercial disputes is much higher. The goodwill that is involved in commercial disputes is much higher. So is for that purpose that end is required to be put, and that is put by the arbitration. So that is why arbitration generally handles only the commercial dispute.
Okay, sir. Thank you so much, sir, for the insightfulness over the virtual procedures or online arbitration practices which have been adopted even partially. If not, for an entire arbitration could significantly reduce the cost of travel and of organizing physical hearings. Now I would like to request Surendra Gedam, sir, to deliver the formal vote of thanks. Over to you, sir.
Thank you, Rudrashri. Respected Dr. Vikram Yadav, Associate Professor, National Institute of Construction Management and Research, Hyderabad. Dr. Payal Thavre, Madam, HOD Postgraduate Teaching Department of Law, RTM Nagpur University, faculty members, my colleagues, and dear participants. A very good morning to all. I, Surendra Geda, on behalf of Postgraduate Teaching Department of Law, express my deep sense of gratitude towards Sir for sharing your knowledge and experiences in the field of online arbitration, which will definitely be helpful to the participants. We are thankful to you for sparing your valuable time for this event. I am thankful to our own HOD, Dr. Payal Thavre, Madam, HOD Department of Law. It is only because of your positive encouragement, Madam, we were able to successfully organize this webinar. Thank you so much, sir, for the insightful conclusion on three basic codes, that is change is the eternal thing in the world. Adopt with the changing technology, and the future is robotic arbitration. I would like to express my thanks to all the volunteers involved in the webinar and all participants for joining this webinar. Thank you once for all your support in making this webinar a success. Thank you once again. Please note, feedback link has been posted in the chat box. Kindly fill it up. Second, you will get the certificate within 10 days after feedback form is submitted. Please subscribe to our YouTube channel to be our series of webinars. Thank you very much.
Thank you, sir, and thank you, organizers, for giving me this excellent opportunity, particularly my mentor, Payal Madam, because she is the one who has taught me the technology law, and that has created an interest in me to get myself engaged into this area of technology law. So thank you so much, ma'am.
Thank you, Vikrant. It was always a pleasure. Pleasure is mine. Thank you.
Thank you,
so much.
Yes.
Sir, there is just a small request. I request everyone to just turn on their cameras so that we could have a photo for the record of the department. I request every participants to kindly switch on their cameras, please. Okay, thank you so much, sir.
Thank you. Thank you all.
Thank you. Thank you.
Thank you so much, sir.
I request everyone to kindly give your feedbacks. The feedback form is in the chat box. Until unless you have given your feedback, e-certificates won't be issued.